She had spent her life on the federal bench, sentencing corrupt officials, throwing out illegal arrests, and guarding the Constitution she had sworn to defend. She drove a sleek midnight blue Mercedes-Benz that she had paid for in full with her own money. Her federal court identification hung from a lanyard around her neck. Yet on one ordinary evening, none of it protected her. To Officer Harlan Crow, she was simply another black woman who had no business driving a car like that. What happened next would set off a national firestorm, expose deep corruption inside a police department, and end more than one career. Karma came roaring in like a freight train. To understand why this story matters so much, you have to know who Judge Lila Bennett was before that night stripped everything down to its rawest truth. Judge Lila Bennett was born in Savannah, Georgia, not the postcard version of mint juleps and horse-drawn carriages, but the Savannah of cramped rental houses on the east side, where gutters filled with standing water after every rain and school textbooks still spoke of the Soviet Union as a present danger. She was the second of 4 children born to Eleanor and Walter Bennett. Her father drove a city sanitation truck for decades. Her mother cleaned houses 5 days a week and sang in the choir at Bethlehem Church on Sundays with a voice that could move grown men to tears. Lila was never supposed to become a federal judge. According to the math of her neighborhood, she was meant for something smaller and safer. A school teacher, perhaps, or a nurse's assistant. That was not a judgment on her family. It was simply the arithmetic of limited opportunity. The numbers said, stay small, stay safe, stay inside the lines already drawn for people who looked like her. Lila Bennett refused those numbers. She read every book in the school library and then began requesting interlibrary loans. She worked weekends bagging groceries at a Piggly Wiggly, saving enough to buy a suit for her first mock trial competition as a teenager. She won. She won again the next year. By the time she graduated from Johnson High School, she had scholarship offers from 4 universities and a letter of commendation from a state senator who had somehow heard about the girl from the East Side who could argue like a veteran litigator. She attended Spelman College on a full academic scholarship, graduated summa cum laude, and went straight to Yale Law School, finishing at the very top of her class. She clerked for the 11th Circuit, then spent years as an assistant federal prosecutor, arguing complex fraud and civil rights cases with a precision that made opposing counsel visibly uneasy. She was nominated to the United States District Court for the Southern District of Georgia, a nomination that sailed through confirmation with rare bipartisan support because her record was simply beyond reproach. By then she had already served years on the federal bench. She had written opinions later cited by the Supreme Court. She had presided over cases involving public corruption, civil rights violations, and police misconduct, the last category carrying special weight for her, because from the highest seat in the courtroom, she had seen exactly how law enforcement machinery could be turned against the very people it was meant to protect. She drove a sleek midnight blue Mercedes-Benz E35, that she had purchased with a check, written in her own hand at a dealership in Atlanta, the way her father had taught her to buy anything important, with money she actually possessed. She wore her federal court credential on its lanyard every single day, not out of vanity but out of her hard-won practicality. Lila Bennett had learned, as every black professional in America eventually learns, that you carry proof of your personhood close to your body at all times. She was driving home from a late dinner with her husband, Dr. Adrian Bennett, a cardiologist, when the blue lights appeared in her rearview mirror. The road was a familiar 4-lane stretch just south of the historic district, well lit and well traveled. Lila was in the right lane, moving at a safe speed. Adrian sat in the passenger seat, quietly reviewing a patient's post-operative notes on his phone. They had been talking about their daughter's college applications. Ordinary, warm conversation on an easy evening after a good meal. Then, the lights came on. Lila felt it first in her stomach, that particular tightening that has no name in any legal textbook, but that every black driver in America recognizes instantly. Not guilt, Not even surprise. Something older than both. She pulled over calmly and completely, coming to a full stop under a streetlight, and put the car in park. "Just stay calm," Adrian said quietly, though his voice had tightened too. "I am calm," she answered, and she was. She was terrifyingly, professionally calm. Officer Harlan Crow was in his mid-30s and had been with the department for several years. He walked with the rolling, confident gait of a man who believed he set the terms wherever he stood. He had a square jaw, close-cropped hair, and pale eyes that turned flat and evaluative the moment they landed on someone. He had never been promoted, though opportunities had existed. Community complaints, especially from black residents in his patrol zone, had twice slowed or stalled the process. None had resulted in formal discipline. They had simply been filed and quietly forgotten. His partner that night was Officer Nolan Pierce, still early in his career, and still deferring to the man behind the wheel. Nolan was not a bad person. He would prove that later, in ways that mattered. But that night he was a follower, and Harlan Crow was leading. Crow approached the driver's side. Lila had already lowered the window fully. Her hands rested in plain sight on the steering wheel. Her badge and court identification were visible on the lanyard. "License and registration," Crow said. No greeting, no explanation, just the two words, flat and aggressive. "Of course, officer," Lila replied, "but may I ask what I was stopped for?" "License and registration first," he repeated. She handed them over without further comment. She watched his eyes move to the lanyard. She watched him read the words. "United States District Court, Southern District of Georgia, Judge Lila R. Bennett." She watched his face do something complicated and unpleasant. He took the documents back to his cruiser. Adrian reached over and took her hand. Neither of them spoke. Several minutes passed. When Crow returned, his entire posture had changed. The swagger was gone, replaced by something harder and more deliberate. The body language of a man who had made a decision and intended to see it through. "Ma'am, I'm going to need you to step out of the vehicle." Lila frowned. "I'm sorry?" "Step out of the vehicle, please." "Officer, I asked what I was stopped for. You haven't answered, can you?" "The vehicle you are operating has been flagged as stolen. I need you to step out now." The silence that followed was absolute. Adrian, a cardiologist accustomed to crisis, felt his heart rate spike in a way it almost never did outside an operating room. Lila turned to look at her husband. For one fleeting moment, something raw and unguarded moved through her eyes. Not fear exactly, but the clear recognition of exactly what was happening and what it meant. Then the moment passed, and Judge Lila Bennett became the most composed person on that road. "Officer," she said, her voice measured and clear, "I purchased this vehicle from a Mercedes-Benz dealership. I have the title. I have the bill of sale. I am a United States federal judge, and that is my court credential around my neck. I would like to know the basis for this stop, and I would like to call my attorney." "Ma'am, step out of the vehicle." She stepped out. What happened in the next several minutes was captured on 3 separate recording devices: Officer Crow's body camera, Officer Pierce's body camera, and Lila Bennett's own phone, which she had quietly placed face up on the dashboard before she opened the door. That quiet, practiced act of self-preservation by a black woman who had spent decades in courtrooms and knew exactly what evidence was worth would later prove to be the most important decision of the entire night. Crow told her the vehicle's VIN had returned a stolen flag in the system. He did not explain how or when the flag had been entered. He did not ask for documentation. He did not wait for any supervisor or verification. He told her to place her hands behind her back. "I will not resist," Lila said loudly and clearly for the recording. "I want it noted that I am complying under protest and that I am a United States federal judge. I want it noted that no verification of this stolen vehicle claim has been sought or received." Crow handcuffed her anyway. She was placed in the back of the patrol cruiser. Adrian, who had gotten out of the car, was told to step back by Pierce, which he did slowly, hands visible. because Adrian Bennett was also a black man on a dark road in Georgia, and he understood the full weight of that fact even in his fury. "Sir, you need to call Judge Renee Calloway," Lila called from the cruiser window before Crow closed it. "Call her right now." Adrian was already dialing. The stolen vehicle flag had not come from any active theft report. A Mercedes-Benz E35O with that VIN had been reported stolen years earlier, before Lila ever purchased her car. The report had been for a different vehicle. A data entry clerk at a dealership had transposed 2 digits in the VIN. The error had been flagged by the State Crime Information Center before she bought the car. The flag should have been rammed. It had not been, not because the system could not accommodate the correction, but because someone had simply failed to do the job. But there was something else. Something that would make prosecutors' faces go pale when they finally reviewed the full timeline. Officer Harlan Crow had run this exact VIN before. He had pulled over a white couple driving an identical model. The system had returned the same stolen flag. He had checked their documentation, confirmed the discrepancy was a database error, and let them go with a note in his report. Possible data error. Recommend correction. He had recommended the correction for a white couple. He had not extended the same courtesy to Judge Lila Bennett. He had arrested her instead. Lila was taken to the county detention center. She was processed. She was fingerprinted. She was placed in a holding cell, while her attorney Damian Shaw, a former federal prosecutor who had once argued before the Supreme Court, drove across the city with copies of her vehicle title, her bill of sale and printouts from the state DM-5 confirming her ownership. She sat in that cell, in the same clothes she had worn to dinner. She did not cry. She later told Shaw that she spent the time walking through the entire sequence of events in her mind, cataloging every detail, noting every procedural failure, filing it all in the precise mental architecture of a woman who had spent her career turning facts into arguments. She was not a victim in that cell. She was a witness. She was building her case. When Shaw arrived and presented the documentation, the desk sergeant looked at the paperwork, looked at Shaw, and said with breathtaking lack of self-awareness, "Well, the flag was in the system. Officer Crow was just doing his job." Shaw looked at him for a long moment. "Sergeant," he said quietly, "your officer arrested a sitting United States federal judge based on a data error he had already identified and flagged when the driver was white. I would choose your next words with considerable care." Lila was released. She walked out of the detention center in the same dress she had worn to dinner. Adrian was waiting at the curb, his hands shaking slightly despite himself. She got into the borrowed car and drove home without speaking for a long while. Then she said quietly, "We're going to sue them." Adrian said, "I know." Word spread quickly through the city and even faster through the legal community. By the next day, Judge Renee Calloway, Lila's colleague on the federal bench and her closest friend for years, had already called twice. The federal courthouse was buzzing. The United States Attorney had been briefed and was on the phone with Police Chief Victor Lang. Lang was a career administrator who had spent more time managing optics than managing officers. He was not a cruel man exactly, but he was a deeply political one. The kind of leader who navigated controversy by absorbing it, softening it, and redirecting it until the original shape was no longer recognizable. He had survived several major use-of-force controversies through internal investigations that found no wrongdoing and press releases that expressed deep concern without ever producing accountability. His response to the Bennett situation followed the same playbook. In an internal meeting that morning with his deputy chief, Patricia Ellison, and the department's legal counsel, Miranda Cole, the conversation reportedly went something like this. The arrest had been technically procedurally defensible because the flag was in the system. Crow had followed protocol. The problem was not the arrest. The problem was the optics. The solution was to get ahead of the story, express appropriate regret for the inconvenience to Judge Bennett, quietly get the database flag corrected, commend Officer Crow for his dedication, and let the whole thing die. That was the plan. It was a bad plan. Miranda Cole, the department's own legal counsel, knew it was a bad plan, and said so explicitly. I advised Chief Lang that the disparity in treatment between this stop and the prior incident involving the same VIN represented significant civil rights exposure. He acknowledged this, but indicated he felt the reputational risk of disciplining Crow was higher than the legal risk of inaction. I disagreed. She put it in writing. That memo would eventually become a key exhibit in the federal lawsuit. Meanwhile, Lang called a press conference. He expressed deep concern for the experience Judge Bennett had endured. He announced a review of the database flagging process. He described Officer Crow as a dedicated officer with a strong record of service, a characterization that required a fairly creative reading of a file containing multiple community complaints. He said nothing about the prior incident with the white couple and the same VIN. He did not suspend Crow. He did not reassign him. Lila Bennett watched the press conference from her chambers, her hands folded on her desk, her expression unreadable. Damian Shaw filed the civil rights lawsuit soon after. The complaint named Officer Harlan Crow, Officer Nolan Pierce, Chief Victor Lang, and the city. It alleged racial discrimination in violation of the Equal Protection Clause, unlawful arrest under the Fourth Amendment, and civil rights violations under federal law. It sought compensatory and punitive damages. The discovery process that followed produced evidence that nobody in the police department's administration had apparently thought to hide, perhaps because they had never really believed they would be held accountable for any of it. Damian Shaw was a seasoned civil rights litigator with decades of experience and the particular patience of a man who understood that the truth in legal proceedings almost always surfaces if you are willing to dig long enough and stay calm while doing it. He dug. What he found was not one smoking gun. It was an armory. The first major discovery came from the database records. Shaw's team, working with forensic technology analyst Theo Grant, pulled the complete log of every time the VIN of Lila Bennett's Mercedes had been queried in any law enforcement database. The log showed multiple queries, all in the same county, all at night, all involving black drivers. Every single stop had resulted in either an arrest or prolonged detention. None of the drivers had been informed they could resolve the issue by providing documentation of ownership. None had been treated the way the white couple had been treated. Theo Grant prepared a detailed forensic report on the query logs. He would later describe his findings in a deposition. The clearest pattern of disparate treatment I have encountered in my career analyzing law enforcement database records. The second major discovery was the emails. Through subpoena, Shaw obtained internal department email traffic involving Crow, his supervisors, and the department's legal counsel. The emails were devastating. There was an email from Crow to his supervisor, Lieutenant Miles Corbin, sent after the white couple incident, in which Crow wrote, "Heads up that flagged VIN is back in rotation. Might be worth keeping an eye out." Corbin had replied, "Good to know." No correction request had been filed. There was an email chain between Chief Lang and Deputy Chief Ellison from the morning after Lila's arrest, in which Lang wrote, "Need to get out in front of this. She's a federal judge, for God's sake. The last thing we need is a PR disaster." Ellison replied, "Crow's record is complicated. Are we sure we want to tie ourselves to this one?" Lang responded, "We have to back our officers, full stop." There was Miranda Cole's memo, the one that had sat in Lang's desk drawer. And then there was the deposition of Officer Nolan Pierce. Pierce had clearly spent a long time thinking about what had happened that night. He was young, had a wife and a newborn daughter, and he had an apparently functional conscience. His deposition lasted hours and became the most consequential single document in the entire case. Pierce testified that when Crow ran the plates and received the stolen flag alert, he had said before exiting the cruiser, "Oh, this should be good." Pierce had not understood the comment at the time. He understood it now. Pierce testified that he had been aware of the earlier incident with the white couple, and that Crow had discussed it in the break room as a near miss, laughing about how the couple had freaked out when they saw the alert. Pierce testified that after Lila's arrest, riding back to the precinct, Crow had said, "Some people need to be reminded that their credentials don't mean what they think they mean." Pierce had written this in his personal journal that same night because he said in the deposition, "I knew something wrong had happened, and I wanted a record of it, even if I wasn't brave enough to do anything about it yet." Pierce's personal journal became a key exhibit. When Shaw finished the deposition, he reportedly sat in silence for a moment, then looked across the table at Pierce and said, "Thank you for telling the truth." Pierce said, "I should have told it sooner." The trial of Bennett versus City began on a Monday morning in the United States District Court for the Southern District of Georgia, not in Lila Bennett's own courtroom, but in the courtroom of her colleague, Senior Judge Theodore Langford, a former civil rights attorney who wore bow ties and had a reputation for running the tightest ship in the district. The gallery was packed. Federal judges from 2 circuits were in attendance. Legal journalists from major outlets had reserved seats. Lila Bennett sat at the plaintiff's table in a deep burgundy suit, her hands folded in front of her, looking by multiple accounts less like a litigant and more like a person who had been waiting a very long time for a particular appointment and had finally arrived. The city's defense was handled by outside counsel. The city had retained a prestigious litigation firm led by a senior partner named Reginald Thorne, because Miranda Cole had made clear she would not defend a case she had already told them they would lose. Thorne was experienced, unflappable, and working with a genuinely terrible set of facts. He knew it. He focused his strategy on process. Yes, the database error was unfortunate. Yes, Officer Crow could have handled the situation more sensitively, but he had followed lawful police procedures, and the city could not be held liable for an individual officer's procedural compliance with an erroneous database record. It was a defensible argument, technically. Damian Shaw dismantled it in opening statements. Standing at the podium, speaking in the quiet, even tone of a man who doesn't need to raise his voice to hold a room, Shaw told the jury, 8 members including 4 black jurors, 2 Hispanic jurors, and 2 white jurors, about the black drivers and the 1 white couple. He put the database query logs on the screen. He put the dates on the screen. He put the outcomes on the screen side by side. White couple, documentation check released. Black driver after black driver, arrested or detained for hours. He told them about the email in which Crow said of the flagged VIN, "Oh, this should be good." He told them about the journal entry, the one where Crow said some people need to be reminded that their credentials don't mean what they think they mean. He told them that Officer Crow had identified this database error earlier, had elected not to correct it, and had used it deliberately, systematically, repeatedly as a pretext. Then he said, "Ladies and gentlemen, Lila Bennett is a federal judge, but I want you to set that aside for a moment. I want you to see her as what she also is. A black woman who was driving her own car on a public road, who presented her credentials and her documentation, who was compliant and professional in every respect, and who was handcuffed in front of her husband and placed in a jail cell because a police officer decided that her credentials didn't mean what they should mean. That's not a procedural compliance case. That's a civil rights case. And it's been a civil rights case since the moment Harlan Crow looked at her court badge and decided it didn't count." The courtroom was very quiet. The defense put Crow on the stand. It was a strategic calculation that, in retrospect, most legal observers agreed was a catastrophic mistake. Thorne had probably known it was risky, but not putting Crow on the stand would have been its own kind of disaster, an implicit acknowledgement that the officer's conduct could not bear scrutiny. So Crow took the stand in his dress uniform and answered questions in the flat, professional tone of a man who had been coached exhaustively. He held up under direct examination. He explained the procedure. He explained the database alert. He explained that he had no way of knowing at the time whether the alert was erroneous. He said he had treated Judge Bennett with full professional respect. Then Shaw cross-examined him. The cross-examination lasted hours. It was, by the accounts of every journalist and legal observer present, one of the most methodically devastating examinations in recent federal court history in Georgia. Shaw moved slowly, piece by piece, building a wall out of every brick of evidence discovery had produced: the earlier incident, the query logs, the email, the journal entry. He put each one up, asked Crow to confirm or deny, and waited. The moment everyone present would remember came when Shaw placed Miranda Cole's memo on the screen and asked Crow, "Officer, were you aware that your department's own legal counsel advised Chief Lang that your conduct represented, and I'm quoting, significant civil rights exposure?" The objection was sustained on relevance grounds, but it didn't matter. The jury had seen it. The memo was in the record. Senior Judge Theodore Langford, in his bow tie, watched the proceedings with the expression of a man who had seen many things in decades of law and was currently watching something he would tell his grandchildren about. Lila Bennett testified. She spoke for hours. She described the stop, the arrest, the cell. She described sitting in the holding cell and going through the evidence in her mind while she waited. She described walking out. She described what it meant, not just to her, but as a pattern, a system, a weight carried invisibly by millions of people who do not have her credentials, or her resources, or her attorney. She didn't cry. She didn't raise her voice. She was throughout simply and absolutely clear. At one point, Shaw asked her, "Judge Bennett, in your years on the federal bench, you have presided over many cases involving allegations of racial discrimination in law enforcement. How did this experience change your understanding of those cases?" She was quiet for a moment. Then she said, "It didn't change my intellectual understanding. I always knew academically that these things happen. What changed was everything else. When you sit across from an officer who can look at your court badge and decide it means nothing, you understand in your body, not just your mind, what it means to be treated as though you have no standing, as though the law that you have given your life to does not apply to you. That is not an academic understanding. That is something else entirely." The jury deliberated for an extended period. They found in favor of the plaintiff on all counts. They awarded Lila Bennett substantial compensatory and punitive damages. When the forewoman, a school administrator named Isabella Soto, read the verdict, the gallery erupted. Judge Langford gavelled for order twice before the room quieted. Lila Bennett sat still, her hands folded, and allowed herself once, briefly, to close her eyes. This is the part of the story where the bill comes due. Not just the monetary award, though that was real and significant, and the city would ultimately pay every cent. The deeper bill, the one collected not by a jury but by time, by consequence, by the particular gravity of choices that seemed, in the moment of their making, like they might simply be absorbed and forgotten. Harlan Crow was terminated from the police department in the wake of the verdict. The termination was framed as being in the best interests of the department, the language of institutional self-preservation rather than accountability. But the result was the same. He was done. He spent the following period attempting to find employment with other law enforcement agencies. His termination from the department, combined with the federal civil rights verdict, now attached to his professional record, followed him everywhere. Agencies conducted interviews and then went silent. One small county department hired him briefly before a community group held a public meeting and presented the commissioners with a detailed account of his history. He was let go. Later, Harlan Crow was working at a security desk at a strip mall, checking bags and watching monitors, making minimum wage. This was not karma by itself. This was simply consequence, the functional result of what happens when a documented record of discriminatory conduct follows a person through their professional life. Karma, in the fuller sense, arrived later. Crow was pulled over on the interstate by a state trooper named Cassidy Lane, who clocked him speeding on a rainy night. It was a straightforward traffic stop. But when Trooper Lane ran his plates and license, a separate, unrelated administrative flag came up. A paperwork error related to a lapsed vehicle registration that Crow had actually renewed, but the DMV system had not yet updated. Trooper Lane asked Crow for documentation. He produced it immediately. She verified it, confirmed the flag was a database error, and sent him on his way with a warning about the speeding. He sat in his car for a long time after she drove away. He later described this moment in an interview with journalist Aurora Klein, who was writing a magazine piece on the case. "I sat there, and I thought about how she just checked the documentation and let me go. And I thought about the thing I had done, and the way I had done it, and I don't know how to say this right, I felt the size of it in a way I hadn't before. When it's happening to you, even just almost happening to you, you feel how big it is." Aurora Klein asked him if he had apologized to Judge Bennett. He said no. She asked if he intended to. He was quiet for a moment. Then he said, "I don't think an apology would mean much for me at this point." This was perhaps the most accurate thing Harlan Crow had said in years. Chief Victor Lang retired in the wake of the verdict, citing health reasons. He left without his full pension, a finding by the city's ethics board, triggered by Miranda Cole's memo and the email evidence produced at trial, determined that his decision to suppress material information about Crow's prior conduct constituted a breach of his fiduciary duty to the department. His deputy chief, Patricia Ellison, was passed over for the chief position and resigned later. She currently works as a private security consultant. Lieutenant Miles Corbin, who had received Crow's warning email about the flagged VYN and done nothing with it, was suspended without pay and demoted. He remains with the department at that rank. Miranda Cole, who had written the memo, who had told Lang he was wrong, who had kept a copy of that memo, was promoted. She was appointed the department's Director of Legal Affairs. She implemented a mandatory civil rights training protocol for all officers and a revised database discrepancy procedure requiring supervisory review before any arrest is made on the basis of a stolen vehicle flag alone. There is something quietly important about that last detail. The way the person who told the truth was also the person who ultimately built something better out of the rubble. Officer Nolan Pierce, the partner who had finally told the truth in that deposition conference room, had submitted his resignation from the police force the same week he gave his testimony. He told Aurora Klein that he could not, in good conscience, continue wearing a uniform while the department's response to the Bennett incident was unfolding the way it was. He enrolled in a criminal justice reform program. He currently works as a juvenile justice counselor in the county, working with young people who have had early contact with the legal system. He is, by multiple accounts from colleagues and supervisors, very good at his job. He reached out to Damian Shaw after the verdict and asked for Judge Bennett's contact information. He wanted to write her a letter. Shaw relayed the request. Lila Bennett agreed. She received the letter on a quiet morning. It was several pages handwritten in careful block letters. She read it in her chambers with the door closed. She later told her husband that it was, in its way, the most honest piece of writing she had received in the entire aftermath of the case. She wrote back, one page, equally careful. She did not offer absolution. It was not hers to give, and she was too experienced a jurist to pretend otherwise. But she thanked him for his honesty and said that the courage to tell the truth, even belatedly, was not a small thing. He keeps both letters, apparently, in a frame on the wall of his office. The monetary award was paid in full by the city. A portion of it, Lila announced publicly, would be donated to 3 organizations: the Georgia Legal Services Program, which provides civil legal assistance to low-income Georgians, the NAACP Legal Defense Fund, and a scholarship fund she established at Johnson High School, her alma mater, specifically for students pursuing careers in law. The scholarship is called the Eleanor Bennett Memorial Scholarship, named for her mother who sang in the choir at Bethlehem Church and cleaned houses 5 days a week and never stopped believing that the math of her daughter's circumstances could be refused. Eleanor Bennett had passed away before the arrest. She never knew what happened on that road that night. She never knew about the cell, or the handcuffs, or the verdict, or the scholarship that carries her name. But she knew her daughter. She had always known her daughter. Lila Bennett returned to her courtroom when she eventually resumed her duties. The day she returned, she walked through the lobby of the federal courthouse, past the security checkpoint, took the elevator, and entered her chambers with the same measured, deliberate pace she had always carried. She hung her coat. She sat behind her desk. She looked at the stack of case files waiting for her attention. Motions, briefs, a preliminary hearing, a sentencing. She put on her robe. She walked out to the bench. She said, "We're on the record. Let's begin." And then there is this. In the period that followed, Judge Lila Bennett presided over a civil rights case involving a complaint filed by black residents of the county against a local municipality for discriminatory code enforcement practices. The case was complex, the evidence dense, the legal questions difficult. She presided over it for months. She issued a detailed opinion finding for the plaintiffs, ordering the municipality to restructure its enforcement protocols and pay substantial damages. The opinion was later cited by other federal circuits as a model for analyzing pattern evidence of municipal discrimination. When a reporter from the local newspaper asked her at a public forum that spring whether her personal experience had influenced the opinion. In that case, she considered the question for a moment and then said, "Every judge brings their full self to the bench. Every experience, every scar, everything they have learned about how the law works and how it fails. The question is not whether experience influences judgment. The question is whether you have the rigor to make sure it clarifies your thinking, rather than distorting it. I have spent my entire career trying to make sure I do that. I believe I do." She paused and then, with the closest thing to a smile she apparently allowed herself in professional settings, added, "The law looks different from inside a holding cell. I think every person who interprets it should know that." There is a version of the story that ends with the verdict and calls it justice. The award, the terminations, the scholarship. Case closed. But Lila Bennett has been careful in every interview and public statement she has given since the trial not to let the story end there, because the version that ends at the verdict implies that the system worked, that one exceptional woman with extraordinary resources and an extraordinary attorney and extraordinary evidence proved her case and was compensated, and therefore everything is on balance fine. She does not believe everything is fine. She is specific about this in the way that only people who have sat on both sides of the law's apparatus can be specific. She said she had a lifetime federal appointment and could not be fired or pressured by the people she was suing. She had Damian Shaw, one of the best civil rights litigators in the region, who took her case in part because he had a practice and a reputation that could absorb the risk and the time. She had a phone on her dashboard recording from the first moment of the stop. She had in Nolan Pierce, a witness whose conscience ultimately outweighed his institutional loyalty. She had the database query logs that Theo Grant could analyze and present. She had Miranda Cole's memo. Remove any one of those factors. Remove two. Consider the same stop happening to a woman who works at a nail salon, or to a college student heading home from a part-time job, or to a man who doesn't have a recording running before he steps out of the car. Consider how that case goes. The math of that version is different. This is what Judge Bennett talks about when she talks about the case, not the verdict. The other drivers, The ones who were detained or arrested on the same false flag and had no badge and no attorney and no telephone recording and no federal appointment protecting their livelihood. Most of them didn't sue. Most of them did not have the resources to try. One of them, a warehouse worker named Darius Washington, had spent a night in jail and lost his job because he missed a morning shift, and his employer didn't accept "I was wrongly arrested" as a sufficient explanation for his absence. Shaw's firm, after the verdict, filed cases on behalf of several of those drivers. Some settled. Darius Washington received a settlement. He used part of it to go back to school. He is currently finishing an associate's degree. He and Lila Bennett have never met. They were arrested by the same officer on the same false pretense, in the same county in the same period. Their lives are separated by everything that structural privilege can create between two people: education, income, legal protection, institutional credibility. And yet, on that night, the same handcuffs that touched her wrists had touched his. This is what Lila Bennett means when she says the story doesn't end at the verdict. The verdict was for her. The system that made the verdict necessary was for everyone. Later, on a quiet drive, Lila Bennett drove the same familiar road in the same midnight blue Mercedes, alone. She drove it at a safe speed in the right lane and the streetlight where Crow had stood with his clipboard and his flat eyes. She drove the whole length of it and then turned around and drove it back. Then she went home. She did not speak publicly about what she was thinking during that drive, but she told Adrian later that night that the road looked exactly the same as it always had. Well lit, ordinary, the kind of road you drive 100 times and never think twice about. She said, "I want to get to the point where I drive it, and I don't think about it. I don't know if I'm there yet." Adrian asked, "Are you?" She thought about it. "Not quite," she said, "but closer." That perhaps is the most honest thing in this entire story. Not the verdict, not the endings, not the scholarship or the citations or the forensic report. The fact that justice, even when it arrives in the form of a substantial jury award, does not automatically become peace. That the road still carries the memory. That a woman who has given her life to the law still has to work consciously, deliberately, every single time, at not flinching when blue lights appear in her rearview mirror. That is the weight of it, the full, actual weight. And that more than any verdict is why this story has to be told. If this story has moved you, there is a reason. Because this isn't a story about one bad night or one bad cop. It's about a system where black drivers were treated one way and one white couple was treated another. And the only person with the resources to fight it, one federal judge with perfect evidence and a world-class attorney, is the one we even know about. Imagine the thousands of Darius Washingtons who never had their moment in court. If you believe that accountability matters, that the truth deserves to be heard, that stories like this one need to circulate further and wider than the courtroom where they were won, then do something with this. Like it, leave a comment, and share it with someone who needs to hear it. And if you're not subscribed yet, this is your sign. Because we don't stop at comfortable, we go where the real stories are.